A transport company in Nigeria has lost its legal battle in a matter bordering on refund of money to passengers for trips not undertaken. This is following the setting aside of its non-refund policy by an Enugu State High Court, as it is believed that the policy is mostly used by service providers to prevent returning payments made to them by client users. The court, through Honorable Justice Aja of the Enugu High Court, declared the no-refund policy as illegal, null and void in light of the provisions of Section 120, 104, 129A and B on the Federal Competition and Consumers Protection Act 2019. Speaking to legal practitioners in Lagos State High Court Ikeja, here's what they have to say.
Before 2019, generally, companies and service providers have been given what's it called? Have been given a policy of no refund after payment. But specifically, January 2019, the President of the Federal Republic of Nigeria assented to the new Federal Competition and Consumers Protection Act 2019, which states expressly that Section 20 of that act, that a consumer can cancel or has the right to cancel any goods or services he has ordered or booked in advance, which is subject to a cancellation charges. Even this delay that makes this lawyer to make cancellation of the ticket he has purchased was caused by them. They delayed the vehicle for good 2 hours. He has paid, he has obtained his ticket, and it was delayed for good 2 hours. After which he requested that they should cancel his ticket, which was not honored. After writing of several letters, they did not honor the request. Then he find his way to the court, which is the last hope of every common man. So I think it's a good judgment. However, the defendant, Peace Mass Transit Limited, still has an option to appeal. But as it is now, it's still the law. We have a law. The Federal the Federal Competition and Consumers Protection Act 2019, and now we have a case law on it too, delivered by the High Court of Enugu State. So it's a good one. It's a good one.
It depends on the circumstances and conditions given to you before you made the payment. If there is a condition that no refund after payment and you have said you agree, you understand, parties are bound by their agreement. So if you have agreed that no refund after payment and you made payment and you're now asking for your refund, if they are not giving you your refund, then I don't think they are liable or wrong in doing so. So that's what I'm saying. You have to consider all the circumstances before you made the payment.
No refund after payment is an illegal policy as far as I'm concerned, and I don't think it is right, because there are some things that can be based on misrepresentation, that can be based on fraud. And once a contract is based on misrepresentation and fraud, the principle of law is clear that such a contract can be rescinded, such a contract can be revoked, and such a contract is bound to fail. So if a contract is based on misrepresentation or is based on fraud, and a party has made payment, and you are not going to say on the basis of the fact that there is a policy that after payment there's no refund, that is even contrary to law, it's contrary to public policy, it's contrary to equity. So I am strongly of the opinion that there is a wrong policy and that it cannot stand the judicial testing. Obviously, it cannot stand it.
From what I learned from the judgments, it was the court delivering a judgment in favor of the consumer who felt wronged by the act of the transport company by not refunding him his money when they failed to fulfill their obligation under the transportation contract he had. So him going to court was to enforce his right as a consumer and relying on the consumer protection laws of our country, specifically the Federal Consumer Protection Act of 2019, in which there are some certain rights that are inures on the consumer, which he can enforce against a service provider, which he did in that regard. And the court awarded punitive damages against the transport company in favor of the lawyer for not meeting their contractual obligations to him.
Meanwhile, many Nigerians have been reacting to the judgment, describing it as an end to impunity among service providers, as the legal practitioners urge all consumers to endeavor to stand up for their rights.